Welcome everyone. I'm Paula Gerber. I'm a Deputy Director of the Castan Centre for Human Rights, and it's my absolute delight to welcome you all here tonight. I'm really thrilled to see such a great turnout for this really important discussion that we are going to be having. And I'd like to begin by acknowledging the traditional owners of the land on which we're gathered today, and to pay my respects to elders past, present and emerging. And I would also like to mention that we are going to be tweeting this event tonight. So if you're interested in following along on Twitter, the hashtag is up there. So please tweet away, and we won't get upset if we see you looking down at your phones instead of at send. But it's also wonderful just to see so many friendly, familiar faces here. So welcome. Let me tell you a bit about Sen. He did his degrees mostly at Sydney, his BA Hons, LLB Hons and PhD, but then did a postgraduate certificate in learning and teaching in higher education at Queer University, which is where he is currently based as an academic in England. And I caught up with Sen over there in October last year, just outside of Manchester, and we're now working together on an application for an ARC linkage grant that is looking at Australia's role in protecting the rights of LGBTI people in the Asia Pacific region, because we tend to be very good at advocating for and protecting our own rights here in Australia, as we saw in the marriage equality advocacy campaign. But we focus less on the countries in our region, and really there are, I think at last count, about 19 in the Asia Pacific region where it's still a crime to be gay. So there's a lot of work I think that we can be doing in that space. So I'm looking forward to working with Sen on that project. As I said, he is based in Queer Law School in England. He has been there since 2017. He's in the Gender, Sexuality and Law and Emotions in International Research Clusters. Prior to that, he was a scholar in residence at New York University Centre for Human Rights and Global Justice, and he has taught at Sydney University Law School and is a Fellow of the UK Higher Education Academy. He served on the board of Amnesty International in Australia in the past, and he is currently on the board of Amnesty International in the UK, so doing a lot of activist work as well as his academic work. But really why we've got him here today to speak to you is he does such interesting, fascinating work. For many, hands up who's in the law here, who's a lawyer? Yeah, a fair few, and a lot of us are black letter lawyers. We look at the law, we interpret it, we imply it, we analyse it, but rarely do we look at it through an emotional lens or even acknowledge our emotions when we're interacting with the law. And that's where Sen comes in with his really important work, which is to say we can't ignore emotions in the law. And without further ado, I will hand over to the wonderful Sen.
Thank you. Thank you, Paula, for that lovely introduction. I'd like to also acknowledge that we're meeting on Kulin land, and I'd like to pay my respect to elders past and present. This land was never ceded. So tonight I'm going to talk to you about, oh, if this works. No, apparently not. That's right, technical difficulties are what I like. Brilliant. About emotion and myself. No, I'm just kidding. Basically, my work has been in the space of law and emotion. And, you know, when people ask me, you know, why do I come to this particular area of study, why feeling, you know, especially if you're a lawyer, you know, what is it about emotion that is relevant? Well, I'll start with a bit of an anecdote. So I launched my book last week at Sydney Law School, and I had a judge, a former Supreme Court judge, kind of stand up at the end of the launch and ask a question. Thank you, Paula. Who basically said, "Look, I want to stage a bit of a protest." And I thought, "Oh, where is this going?" And he proceeded to say, "Look, I think emotion is something that's too messy, that we need to, and I'll quote him here, pour contempt on emotion in law. And it struck me so immediately that here was a former justice using emotion to talk about why we shouldn't have emotion in law. And so even for those who are invested in this idea of law as a system of dispassionate rules or objectivity, that, feeling should be evacuated from this space, even in making those kinds of claims, emotion is always present. And so regardless of what kind of law you do, whether you're a lawyer, whether you're a barrister or a solicitor, whether you're a judge, whether you're working in law reform, whether you're a parliamentarian, whether you're working in allied disciplines like social work, psychology, and working with people who are going through the legal system, it's really important to recognize that there's emotion everywhere. And for me, my interest has very much been motivated by my work on LGBTI rights, so lesbian, gay, bisexual, trans, and intersex rights. And I was always struck when I started working in this area, when I started this work, it was about 10 years ago with the New South Wales Gay and Lesbian Rights Lobby, and of course Amnesty International, where I've been for 13 years, both here and abroad. And for me, it was really striking how in the activism I was doing, in the law reform conversations I was having, emotion was always present. Different kinds of emotions, different kinds of feelings. And this history is not new. If you think about the various social movements that have existed, such as, the Black Panther movement, women's liberation, gay liberation, emotion has been central to the organizing of those movements and also to the particular kinds of claims, political claims they make, but also the claims they make through law, whether seeking redress through courts, whether lobbying parliamentarians for particular legislative change, and so on. And I start with this quote here by Audre Lorde, how do you deal with things you believe? Live them not as theory, not even as emotion, but right on the line of action, effect, and change. And to me, this is a really useful starting point for thinking about emotion not simply as an individual feeling that we all have, but rather recognizing it has social and political significance. That actually, as a number of Black, lesbian, feminist scholars, and indeed a number of other scholars have written about extensively, emotion, feeling, affect has an enormous currency. And it's an enormously rich space for us to begin thinking about both our political claims, claims for social change, but also how we might go about doing work and how we might go about doing research. So tonight I'm going to take you through a bit of a potted history of emotions and LGBTI rights and law reform. It's going to be a bit of a whistle-stop tour because I'm trying to trace a whole range of different feelings, if you like. I'll also begin by acknowledging that there is a lot of explicit content here, unsurprisingly. I'll be talking about homophobia, transphobia, and things that people might find difficult. So I just want to forewarn people of that content. So let me begin with Disgust. So I have up here a lovely image that I took in the New York LGBT Center. It's in a former bathroom, which is now a meeting room. It's a piece of work by Keith Haring, the famous gay graffiti artist. And, it's quite explicit, as you can see, lots of penises up there and semen being exchanged. And, this begins the discussion around the role disgust has played in the criminalization and regulation of sexual intimacies. For those who aren't familiar, Henry VIII introduced the Buggery Act around 1533 to 34 to criminalize, of course, that evil vice, that is anal sex between men. But following on from that, there has been enormous kind of interest and, if you like, repulsion towards intimacies and relationships and sexual activities that don't conform to the sort of matrimonial, conjugal, reproductive ideal, basically. And if those here who might be familiar with the work of Oscar Wilde, you might be familiar with the fact that he was put on trial for an offence known as gross indecency, which was introduced in the late 19th century in England and Wales. This was seen to be a kind of lesser offence in the sense of you wouldn't have to prove anal sex had taken place, but it was designed to capture a broader range of basically male-to-male sexual conduct. And what's really interesting about these kind of, gross indecency laws and laws criminalising homosexuality, as Paula touched on, which still exist and are a product of British colonialism, is the fact that they're drafted using offence language. They're offences against the order of nature, carnal intercourse against the order of nature, right? You think about those provisions, they criminalise everything from, child sexual abuse through to consensual same-sex relationships. But what's interesting is the logic that plays out in the ways in which offences were historically understood and are in a number of countries today understood, is through this logic of disgust. What is it that we deem disgusting, right? How do we cleave these spaces of sexuality and sexual intimacy that are aberrant, that are alien to us, that are things we shouldn't tolerate, right? And so disgust has a really strong currency in how we think about sexual intimacy, not only historically, but also in our contemporary moment. And this is significant because when you think about law and how it functions, and particularly jurisprudence, it still plays a significant role today. How many of you are former law students and / lawyers now, again? Yes, okay, great. So you might remember in criminal law when you studied the case of Crown and Brown, which involved 16 gay men engaged in quite, uncompromising S&M, sadomasochist sexual activity, everything from kind of piercing foreskins to nailing them on floorboards through to hot wax play. Now, some people might describe that as a good Saturday night. But to the House of Lords, this was torture. This was violence. This was uncivilized cruelty, basically. And what was really fascinating, if you read the judgment, the majority judgment anyway, is that it's laced with this idea that this is uncontrollable sexual activity, right? This essentially was about assault occasioning actual bodily harm. But so many of the precedents kind of slip away as the court kind of obsesses over the kind of sexual practices in this kind of depraved language, right? Interestingly, a few years later, a case came before the Court of Appeal, so not the House of Lords, involving a married couple, a heterosexual married couple, where the husband had branded his wife's ass, basically, with a butter knife. Now, for those who are familiar with the doctrine of assault occasioning actual bodily harm, anything amounting to a wounding is a breaking of the skin that's not transient or trifling. Now, interestingly, the court in that case was able to distinguish this particular activity from the 16 men involved in S&M by saying that, the harm was merely incidental to an activity of personal adornment. Right? This was a loving expression of, matrimonial intimacy, when if you thought of it from a strictly legal perspective, you would say, well, it's still wounding, it's still intentional. You've met all of the criteria here for liability. Why is it not being held to the same standard? Well, you've got homophobic disgust to help you explain this, right? So for me, thinking about disgust and emotion generally in the law isn't just about individual feelings or how, a litigant might feel or how a judge might feel at a particular moment in making a decision. It's actually to think about how emotion becomes a kind of legal or doctrinal concept, a logic that then has precedential consequences. Right? So if you want to understand how cases get decided and distinguished or applied, it's not just about understanding the doctrinal correctness or the particular norms that have been used, but also understanding the emotional or affective logic underlying those cases. So if I move on to thinking about another emotion, it's hate. And so I've talked a lot about how, gay people, lesbians, bisexual people, largely were seen to be these kind of alien, aberrant figures, objects of revulsion historically that needed to be regulated. Now, because of a lot of activism, we've seen a shift away from, that kind of treatment in a general sense to greater concern, at least at a rhetorical level, at in terms of policy and law reform around protecting, I'll be quite specific here, LGBT people from violence and discrimination. And hate crime legislation is seen to be one example of this. So what's quite interesting is the way in which, gay people or queer people broadly move from being these objects of disgust and contempt and hostility and a whole range of other emotions, to suddenly being objects to protect from other people's hatred, from other people's contempt, from other people's hostility. So in the creation of hate crime legislation, this can include everything from, specific penalties in assault that deal with, homophobic motivated violence or transphobic or racist motivated violence, through to anti-vilification laws that prevent speech that incites ridicule, hatred, and contempt for particular groups of people. And what's quite interesting is how hate gets refracted from the kind of homophobe or the transphobe saying nasty things to someone or, bashing someone up or harming them in a particular way, to then the actual homophobe or transphobe themselves, as seen to be alien to a otherwise, socially tolerant community. And a good example of this conversation is in the homosexual advance defense. For those who are familiar, was a historical formulation drawn from provocation largely as a way to mitigate murder to manslaughter, where, the defendant was able to demonstrate, well, they, this particular victim in this instance had made an advance that wasn't consensual or desired, and they lashed out and were provoked to murder them. Right, one of the most famous cases of this is Crown and Green in the 90s, and that was a High Court case. It happened in Mudgee, New South Wales, in the mid-90s. Now, what's really striking about that case, and of course, Michael Kirby, who dissented in that case, held, well, this is a homophobic defense, right? Like, it exists largely to excuse violence perpetrated by straight men against gay men, right? Because they're unable to deal with their own internalized homophobia or kind of disgust and hostilities towards gay or queer people, bisexual people, and men in particular in this instance. But what's really striking about the dissenting judgment as well is the way in which Michael Kirby, in making this argument, kind of dismisses the fact that homophobia is not an otherwise pervasive problem, right? In order to make this argument that the ordinary person would not act this way, of course, because that's how the provocation defense is framed. He needed to make the argument, well, the ordinary person isn't homophobic. But as we all know, that's not true, right? We're implicated in a society where we all deal with homophobia, right? And we're talking in the 90s, and the Attorney General's Department had done a survey around this time which just demonstrated how homophobic violence was endemic, it was rife. People were suffering both kind of physical violence and sexual violence, but also more kind of insidious social and symbolic violence, not going out to particular venues, not going out to particular spaces. So what's quite interesting in the way the defense is framed is that it uses a kind of language of, hostility against the homophobe, but in a way that actually obscures or erases how homophobia is structurally and socially entrenched. So in some ways, while I, of course, I'm much more of a Kirby fan in terms of the judgment than I am the majority's kind of licensing of homophobic violence. But I think it's incumbent for us to also understand what the emotional consequences of this kind of redirection of hate from kind of, the once upon a time scorned and reviled gay person to the now scorned and reviled homophobe, right? Because in this kind of shifting of emotional registers, are we actually dealing with the problems that give rise to this violence in the first place? Which brings us to thinking about anger. And primarily the impetus behind a range of social movements has been the pain of injury, of victimization, but also that sense of indignation, frustration, to kind of move away from those injuries, to push back, to strike back. Right? Anger has been enormously powerful as a resource for people trying to make political and social claims, both of recognition, but also of broader kind of social transformation as well. And so when I talk about anger, and particularly in social movements, I don't want to say that, gay liberation, for example, was about making law reform claims, because that's enormously reductive. It was about challenging a whole range of social systems and institutions of which law reform was a distinctive but, small part. So when we think about the rise of anti-discrimination law, for example, as a way of dealing with the kind of endemic discrimination and inequality that, lesbian, gay, bisexual and trans, and to a lesser extent intersex people who have only recently become recognised federally here in Australia for the purposes of discrimination law, it has been largely a consequence of this kind of activist push. This activist push mobilised by anger. But what's also quite interesting is how courts register anger at experiences of discrimination, right? Because, of course, there has to be a threshold between what is, unlawful, intolerable, illegally intolerable discrimination, and conduct which is, yeah, that's annoying, that's bad, that's a bit demeaning, but it's not legally discrimination. And it's quite interesting when you think about the way cases have to navigate and how courts have to navigate this distinction. And it's largely a matter of anger resurfacing in judgments. Think about the religious discrimination bill currently being debated, right? I think we're at the second or third exposure draft. It just gets worse and worse. And yet, what this debate reveals is how, of course, there's anger from LGBTI people who are really worried about the consequences of their ability to access services like healthcare, their ability to go to work without being intimidated. But it's interesting to see how this law was proposed as a response to something like marriage equality, right? And the anger of so-called, religious groups who felt that suddenly their rights were going to be encroached upon. Right, so you have this interesting kind of conflict emerge, right? These kind of two sides kind of angrily engage with each other, which frame the space of this law reform. But in doing so, there's also the risk of ignoring the fact that this isn't a polarized debate. Of course, there are LGBTI people who are, for example, religious, right? This isn't just about sexuality on one hand, religion on the other. But it's also about recognizing where courts are willing to draw the line between what is religious freedom or what is religiously permissible to do to someone in the context of public life and what is not. About 6 years ago, there was a case here in Victoria where a Christian-run camping resort refused, a group of same-sex attracted, gender-questioning young people accommodation to run their camp because they, disagreed with the promotion of homosexuality. And what was really interesting in the judgment, it went through VCAT and then to the Supreme Court at the time, and the judge said, well, actually, you're a commercial entity. You operate not as a religious provider of particular religious services, but essentially as a resort, right? You don't vet the particular lifestyles of everyone you rent these premises out to, right? And so it's really interesting how the court castigates, in this instance, quite angrily, this particular company for its conduct. And that's important, right? So when I talk about anger and the way anger is mobilized, it's a resource, right? It's powerful, it's effective, it can achieve change, it can hold people to account. But at the same time, we also have to be wary of how it can frame debates in ways that are polarizing, that treat issues as antithetical when they're not, right? And so what reading, for example, anti-discrimination law through anger can allow us to do is to trace these different movements and how they play out. So let's think about an allied feeling to anger, which is anxiety, right? The concern, the frustration, the fact that you are always aware of something that may happen, right? A risk, right? The presence of the yet to come. And for a lot of trans people at the moment, the debates around legal gender recognition really spotlight this enormously, right? Because of course, in the UK where I'm at the moment, where I'm based at the moment, they are reforming the Gender Recognition Act to allow for trans people to self-declare their gender without any medical, surgical or additional bureaucratic measures, right? And this is important reform. However, there's been a kind of spate of kind of anti-trans rhetoric which highlights the risk that trans people pose in bathrooms, right? This idea that they are predatory, that they are, going to prey upon vulnerable people, the fact that trans young people in particular are going through a phase, rhetoric that those of us who are gay or lesbian or bi have heard a lot, now being recirculated and mobilized against trans people. What's interesting, though, about this law reform debate is that it has absolutely nothing to do with the law. Because, of course, you can already go into whatever bathroom you like without any kind of piece of paper validating your entry to it, right? And so many services and refuges, for example, in England and Wales and Scotland, have already been trans-inclusive for a number of years. You know, the Equality Act in the UK has existed, which includes gender reassignment and sexual orientation since 2010, right? So 10 years. And this reform has no bearing on that. Yet what strikes me as really interesting is how these kind of anxious logics get played out, not only in a political and social sense, but also shape the terrain of law reform. Because right now we've seen deferral upon deferral of this reform in the UK. It has yet to come to pass, because politicians are enormously wary of the kind of anxiety that underpins this kind of legislative change. But what's also really significant to recognise is when law refuses to engage in a particular area as well. And so anxiety, in another sense, emerges where, for a lot of intersex people, for example, the law refuses to recognise their violations of bodily autonomy and integrity. Right? They're subject to corrective surgeries from infancy, as one example, because of an anxiety that was clinically kind of, manufactured in the 50s, called a disorder of sexual development, right? And this idea that if your body doesn't match, what a quote-unquote normal boy or quote-unquote normal girl look like, then you're going to have anxieties growing up. You're going to have a psychosocial maladjustment, as the kind of logic of the 50s go, which has carried through in a number of medical protocols. But again, it's interesting here. It's not the anxieties of the kids or the intersex kids in this instance that they're concerned about. It's not the anxieties of the trans kids who are experiencing a lack of affirmation for who they are that they care about. It is, of course, the anxieties of the cis folks, the adults, the people whose gender and sex are being projected onto these young people, but not just their gender, but their insecurities, right? And so in many ways, these law reform conversations are structured by anxieties, not of the people themselves who this law or policy will benefit and will support, but of those who refuse to acknowledge their particular human rights issues and experiences, right? And fear, often very closely related to anxiety. And what better example can we talk about than the way in which the Australian government treats people who seek asylum? So let's begin with what the international law says. If you look to the Refugees Convention, fear is central to it. In order to seek asylum, you must have a well-founded fear of persecution. You must be outside your country of origin. You must be unwilling and unable to seek protection. And that persecution must be based on whether you have a particular political opinion, whether you belong to a particular religion, your race, your nationality, or whether you're part of a particular social group. And of course, for LGBT people specifically, intersex people aren't recognised at the moment within this framework. For the LGBT people, that has been permissible through the particular social group category. But what's really interesting is that so much of the political and legal debate and law reform, and when I say law reform, the Migration Act and the immigration bureaucracies that sit within it, within that or beneath that, is that it's all about fear. Fear of the border being compromised, fear of bogus asylum applicants being let into the country. So rather than focus on the fear of the people who are seeking protection, what again becomes paramount in the context of law and politics is the fear of the decision makers themselves, right? So we see this easily played out at a political level, but what people might not be too familiar with is how this then gets transacted at the bureaucratic level, the decision-making level, when people actually lodge their protection claims. So of course, the now Home Affairs Department and people working within that make these sorts of determinations in, when they screen people and when they interview them for their claims of asylum. Now, if you're a gay person, for example, seeking asylum, you can be asked all kinds of questions, right? Questions relating to your sexual habits, right? How many partners you've had. Questions relating to your cultural taste. Do you like Madonna? Do you like Bette Midler? Questions relating to the kind of clubs that are in existence. Can you tell me how many floors Stonewall has? Right? Again, that's my Sydney example. But, can you tell me about Oscar Wilde? Until recently, I couldn't tell you about Oscar Wilde, right? It's only recently I started to read him. So it's particularly important to recognize that this kind of heightened bureaucratic surveillance to quote unquote understand whether someone is really gay or not represents a bureaucratic anxiety, an anxiety that we need to authenticate who you are, because otherwise the bogus people will come in. Everyone will suddenly claim that they're gay, they're lesbian, they're trans, in order to get protection. Now, of course, that ignores the fact that so many people are vulnerable and at risk when they disclose the fact that they're gay or lesbian or trans, especially given that Australia's policy is to, of course, interdict people who arrive by boat and then warehouse them in offshore prisons, which, of course, up until quite recently also criminalised homosexuality. So, of course, you can see here how this kind of complex legal architecture that deals with asylum claims in Australia uses fear not just at a rhetorical level, at the level of politics, at the way, people talk about these issues, but also manifests in the way the law, policy, and bureaucracy function as well. But it's not the fear of the people who are seeking asylum, again, that gets prioritized here. No. It's the decision makers. It's the people who are enforcing these laws, who are, manifesting them at an individual relational level when they talk to people, when they interrogate people about their particular claims. So again, emotion is pervasive in this instance, right? It's apparent in the treaty, the Refugees Convention, where it's named explicitly as fear. It manifests in the policy and political level in the way people talk about borders and compromised borders and the quote-unquote bogus applicant that may, seek to abuse the system. And it's also present in the scrutiny that decision makers do to people when they're worried about whether or not someone is really gay or not, right? And there's so much that I can say about this, but I won't because I give a separate lecture about this. But, again, it's just another example of how emotion structures the space for LGBTI people specifically, but also people who seek asylum generally, when it comes to these kinds of issues, right? And so let me transition now to something a little bit more hopeful or positive. Love. Right? So when I began the seminar, I was holding a sign, which is "Love is a Human Right," in glitter. That was at London Pride a few years ago. And, it's strikingly obvious that love is central to, marriage, right? Or arguably in the way people talk about it, right? It's the subject of enormous writing and literature and, critical scholarship and these kinds of things. What people also forget that it's not just the hashtag love wins that circulates on Facebook, on Twitter, on Instagram, following a momentous marriage equality decision in this country or that country, but also is a product of jurisprudence. And my example here is quite specific. I'll take us to the United States. So following the Obergefell decision in 2015, where the remaining state bans on same-sex marriage were held to be unconstitutional, love wins was the hashtag. Right? But it was also much more than that. Because if you read the judgment was written by Anthony Kennedy, who's now retired from the US Supreme Court. He was a quote-unquote kind of conservative justice, but he always wrote the pro-LGBT opinions along with the 4 other liberals on the bench. And what was really interesting about this particular case was that it doesn't really mention a lot of precedent, as we might expect, high-level constitutional law case. It talks quite boldly about key values of the US Constitution: liberty, equality, and dignity, because, of course, they have a Bill of Rights and they have equal protection guarantee, their 14th Amendment, and so this structures the space of constitutional jurisprudence, or one area of constitutional jurisprudence. But what Anthony Kennedy talks about for most of the judgment is the love to find a partner, right? The liberty to pursue one's relationship. How does Justice Kennedy talk about equality? The freedom to live from the stigma of inferiority, the ability to aspire to a better future, right? It's hopeful, it's optimistic. Dignity arrives in the judgment as a third constitutional concept in order to protect people from the humiliation that comes from being single, apparently. So, again, I'm just paraphrasing here, right? So, this is the point to take away, is the emotional logic that structures it is quite romantic, right? Kennedy gives you a Valentine to marriage, but not just marriage in a general sense, but a constitutional idea of marriage in the US Constitution, right? It has a legal life. And it's going to be quite interesting to see how this life translates into subsequent case law that deals with relationships and families. But I picked the knot there for a particular reason, because what Kennedy does is he knots together a very specific idea of love and liberty. That is a conjugal intimacy, right? An intimacy between two people. Interestingly, it's Chief Justice Roberts in dissent, who is a conservative justice who didn't endorse marriage equality, who actually kind of makes the, I think, quite apt point, which is, well, why are we limiting to two people, right? I mean, yeah, why are we? Like, if love is the logic here, right, if that is the currency in which equality and liberty have been have framed the space for this decision to be made, then there's no reason why it should be limited to two people, right? So what's quite striking about and again, that was in dissent, of course, but what's quite striking here is how love can be articulated in a really powerful sense and given legal life, but at the same time narrow the space for recognition as well, right? It kind of can limit what you can hope for, what you can achieve. An alternative example, which I think is actually a much better example of kind of pro-LGBT jurisprudence, is the Indian High Court, Supreme Court decision that was handed down in 2018 to decriminalize gay sex. It's the longest piece of jurisprudence I've ever read, at 500 pages, but it's quite a poetic judgment, and it speaks volumes both to queer scholarships. I mean, it literally cites queer scholars like Ruth Vanita, who's an Indian queer scholar, and it also makes reference to kind of post-colonial theory and literature, but also imagines the Indian constitution in these really broad aspirational terms as a kind of living tree, a map for our future, right? And it's really striking because in that judgment, it opens up so much space to move beyond just the decriminalization of gay sex. It creates all these other avenues for the recognition and affirmation of LGBT people in public life. So again, my point is not to just say emotion, like positive emotions are useless or, completely problematic, because of course there can be hopeful and optimistic and loving articulations of intimacy, of identity, of queerness within law, within jurisprudence, but in ways that aren't as knotted or tight as the Obergefell decision was. And to my final example, which is hope. And this is the progress flag. So it's the traditional pride flag with the trans colours and the black and brown colours to represent people of colour. And what's really striking is how hope structures most of our conversations of human rights. The Universal Declaration of Human Rights is essentially an aspirational document, right? That is its legal status. It points to a future where people can enjoy all of these protections, these freedoms of equality, of dignity, rights to work, rights to healthcare, rights to housing, all of these kinds of things, but recognizes it in a future-oriented sense, right? We're not there yet, but we can be there. We have to keep working. We have to work to the quote-unquote progressive realization of these rights. And hope is a really powerful thing. And it's a useful thing. But at the same time, we also have to be quite critical of what hope can do. Sometimes we orient ourselves to particular institutions to deliver us from the discrimination we face, from the inequality we face, while failing to realize that that dream we have is actually misplaced. That actually what we've invested in isn't going to deliver the kind of justice we want, isn't going to deliver the kind of rights we deserve. So an example to kind of bring all of this together is, in the context of asylum, is it about improving refugee law? Is the hope to kind of get more states to recognise the Refugees Conventions, to ratify it, to implement it? Sure, of course. Or is it to kind of move us beyond this conversation, to recognise the value of people just moving where they want to, right? Moving beyond this kind of bordered structure that we live in. Same thing with relationships. Why border relationships around pairs or around gender as it used to be, but why not allow for more creative, hopeful, ethical possibilities, right? And why even think of law reform as the place to deliver us from these kinds of, injustices that we face? So hate crime law. Why do we turn to the criminal justice system when the criminal justice system, as we know, disproportionately incarcerates, for example, here in Australia, Indigenous people, people of colour, right? Why turn to a system that is routinely entrenching inequality as a way to address our own inequalities, when really it probably will exacerbate it, right? So maybe our aspiration shouldn't be for more criminalising, more penalties to deal with particular issues. Maybe we need to think beyond law. So in bringing this discussion together, I like to end with this slide. And part of this was in the queer space when I was at Sydney Uni in 2007. I see Gilbert can smile, he's probably been there since then. And I just remember seeing that and thinking, oh yeah, this seems interesting. I think I can relate to this. And for me, what is so important when we talk about emotion in law is not just some sort of radical subjectivities, I feel this, therefore I think this, therefore it's truth, but rather to understand how emotion is moving, how it organises our spaces, how it organises how we do activism, how we pursue law reform, how it manifests in the kind of litigation we do, the way we frame particular claims for legal recognition, how it's reproduced in the level of judgments when decisions are made, when precedents are set, how it materialises in legislation, right? Emotion is present everywhere. It circulates, and it's something we need to take account of. And, to cite some traditional legal scholars here, it is essentially about ensuring that we are responsible for the kinds of decisions we make. We are responsible for the kinds of claims we pursue in a critical way, right? I'm the kind of person who's been really involved in law reform and trying to achieve particular piecemeal legislative changes for particular kinds of issues, because I see the partial utility of law reform as a way to progress particular kinds of rights claims, rights for LGBTI people. But at the same time, I'm also wanting us to hold space for those critiques, those spaces where we can both recognise that, yes, this is okay, this is decent, this is an improvement, but it's not where we need to end up, right? And that's where emotion can sort of help us, because so often we get caught up in these progress narratives that we tell ourselves, once upon a time we were the objects of scorn, and now we were the outlaws, and now we're the in-laws, right? We're welcomed, we're embraced, we can get married. How great is our life? And certainly for a lot of people, I'm sure that's true. But for a lot of people, that is absolutely not true. Right? So when we tell ourselves these narratives of progress, we kind of create a story that may work for some people, but in doing so erases the experiences of a lot of other people, trans people, intersex people, people seeking asylum, people with a disability, Indigenous people, right? There's so many different kinds of LGBTI communities out there that when we tell ourselves this story, we risk ignoring what the costs of that story are, right? And so in bringing emotion to bear in a lot of these conversations, it allows us to think about, well, why do I feel this way about this issue? How is this emotion shaping the particular kinds of claims that are being pursued, or framing the particular kind of law reform or policy that we're able to have? And so in doing so, we can open up more conversations, right? People like to say, I think a lot of conservatives like to say this, that, facts don't care about your feelings, when really they're very emotional people. They're always easily they're outraged by a gender-neutral bathroom door, or the fact that they is a singular pronoun. I'm constantly amazed at the ways in which they just kind of find the most little thing to suddenly turn into some mass spectacle, right? Because this is the register in which so much of our politics happens, right? At a level of emotion, different kinds of emotions. I've only mentioned a few tonight, and there are so many more that you can think about in your own work, in the places you occupy, in the politics or activism that you're involved in. And so, in order to progress, quote unquote, progress some of these conversations, we have to start thinking about feeling. Right? And taking emotion seriously and critically. That's the key thing here. It's not just about, I feel this, you feel this, okay. It's about understanding where feelings come from, what feelings do, and what they do to us and to others, right? And so essentially, that's where I would like to kind of bring all of this together as a way for us in our own work, whether you're lawyers, whether you're activists, whether, just people interested in social change generally, how can we use emotion critically to further some of the changes that we would like to see, right? So on that optimistic note, I will finish.
Decision to decriminalise. I think you're one of the few people who've read that mammoth judgment. Do you want to talk a bit about the emotion thing?
Oh, yeah, absolutely. So, when I read that judgment, I was back in Sydney actually, and I was home with my parents, and I just basically set aside the whole day to read the judgment. It's 4 justices. It's a unanimous judgment, but they each deliver separate opinions, and each opinion is at least 100 pages long. And so together, what fascinated me about this judgment is that it was a jurisprudence, and I'm not an Indian constitutional scholar, so I'm just going to put that out there now. So, but what struck me about it was just how atypical it was, right? On one hand, it was typical in the sense that, they go through a very thorough referencing of, international law precedent involving things like privacy jurisprudence. For those who are familiar with the decriminalisation of homosexuality, it's largely been done through privacy, which has its own regulating dimensions, but that's been the kind of key prism through which the decriminalisation of gay sex has been possible. And so they talk about that and they mention all of that, but also they talk about history. They talk about colonization. They talk about what was lost through colonization. They talk about what queer scholars literally say, right, about these kinds of issues. I mean, in so many ways, it was kind of critical queer jurisprudence. And, again, whether it was kind of authentic, whatever that means, or whether it hewed to Indian constitutional traditions, I can't answer that because I'm not the expert in that particular area of law. But what I can say is that it was a loving judgment in the way in which it presented LGBT people. I mean, it was focusing on same-sex relationships, but they do mention, of course, trans people because, of course, there'd been a promising judgment earlier, a few years before, to recognize the rights of quote-unquote third-sex people. And so what was really fascinating was the way in which they talk about how it's not just about privacy. In so many of the earlier cases dealing with the decriminalisation of gay sex, it was permissible to decriminalise gay sex because, yeah, it's gross, but we put it in a bedroom so we never have to see it, right? So, of course, when England and Wales partially decriminalised gay sex in the late 60s, that was only between 2 people aged over 21 in a private bedroom space, right? Anything else, no. Sorry, we're not accepting that, right? And again, the reason why, the 16 gay men involved in the Brown case came to attention, it was just a drugs raid. They did this all in a house, in their own private space. But of course it leaked, literally, in terms of the tapes that got circulated that revealed all of these activities. And what the Indian judgment does is it just points to the fact that it's not just about what gay people do in the context of their bedrooms, it's also about their ability to live, their subjectivity and their personhood. So the judgment is enormously rich in how it recognizes a much broader conception of sexuality, or particularly in this instance, homosexuality, as something that's not just reducible to the kind of sex we have, right? to the intimacies and identities that go beyond that as well. So actually, I think the judgment's going to open up space for all kinds of other forms of, LGBT affirmation. But again, we have to wait and see.
Okay, thank you very much. It was a really interesting presentation. I think I have two questions. First of all, what struck me when you talked a lot about anger and hate and a lot of negative feelings.
Sure.
And of course, if you look deeper, we will of course see that this is structural discrimination and prejudice. So my question kind of relates to that. So how do you relate these structural aspects that are underneath these emotions to emotion? And where's maybe the benefit of talking about emotions instead or additionally to these structural aspects? And the other thing that kind of struck me when you talked about the Refugee Convention, how it says well-founded fear, because that's a really interesting part, because on the one hand it talks about feelings, but it also takes the feelings out of it, the subjectivity, when it talks about well-founded.
Yes, absolutely.
And makes it kind of objective, or it wants to make that. And of course we can see that on a lot of levels in the law, that feelings have no place there. So maybe you could go a little deeper into what do you think that does with the law? So what are the effects of this thinking about the law and how, well, which negative consequences does it have?
Sure, absolutely. Yeah, thank you for those questions. So I think what I'm really interested in, and what my book did, it was based on my PhD, was I was really interested in how individuals come to law, particularly LGBT. I focus only on LGBT cases in the book. Intersex, I didn't want to tokenize, so that's quite separate as well. But in this instance, I was focusing on how people, seek out legal redress because they're angry, they're upset, they seek asylum because they're scared, right? So people come to the law because they feel certain things, they feel particular kinds of emotions. What I was really interested in is how those emotions get taken up by the law, right? How they get crystallized and how they get refracted. So in the context of the Refugees Convention, you're right, it's the fear, but it has to be well-founded, right? So in kind of structuring it in those terms, they take the fear of the person and then kind of shift it into another register. Yeah? But also, in doing so, they create a new articulation of fear, or rather a legal articulation of fear. So I was really interested in thinking about how, we go to the law to seek redress for discrimination, violence, persecution, these kinds of things, and we feel all kinds of emotions. How does law then engage with that? How does it take that up? How does it turn it into a concept? And how does it then send that concept back out into the world? Right? So with anger, with anti-discrimination, you're absolutely right. People's experiences of anger reflect structural discrimination that they face, right? It's not just the fact that one person called you a bad name. It's the fact that, you work in a particular space where you can't can't wear the clothes that you want to wear because you're afraid that, people are going to make jokes, the bosses are going to take it seriously or hold people accountable, right? It's structural. It's much more insidious. And then the law kind of then is willing to sort of recognize that a little bit and then say, that's intolerable. We're going to create anti-discrimination law and we're going to strike back against these particular acts. So again, it takes the emotion and then crystallizes it in a particular way and then refracts it against these bad institutions or these bad individuals who perpetrate discrimination. So I think for me, it's interesting to think about how emotion circulates in this way as a way to expose what law is doing. And in a way that we don't often think about or understand. Because sometimes we think, it's just, the decision was made because this was the doctrine or this was the precedent or this is what the legislation says. But actually, if we think in emotional terms, we get a richer understanding of what's going on.
I just wanted to follow up on the anger scene because I don't want to go back to gay lib because I think that the point about gay liberation, it was equally fueled by celebration as it was by anger. And as you were presenting it, I was a bit concerned that half seemed to have been forgotten. And it seems to me the social movements in general are successful as much for what they do to the people who take part in them as they are for the larger impact.
Sure.
My memory, and Jamie and I are probably the only people in this room who can claim to have memories of this, is that we actually weren't that concerned about law reform.
Yeah, of course.
We were concerned about who we were and celebrating it.
Yeah, absolutely. Totally agree.
We're not going to disagree,
no,
so I'll pass the mic on to someone else.
Hi, Sunny. That was amazing.
Thank you.
I just have a question regarding emotions and the recent High Court decision that's about to come out around Pell and what your comments would be around that, particularly for emotion. As a very strong ally and a cousin, having a cousin who's 15 and, you know, coming out and things like that, and works is an altar boy sometimes as well. And I really enjoyed that part with the religious discrimination and that recognition that there are, obviously.
Yeah.
Yeah.
I mean, I'll speak a bit more generally because for several reasons. Yes, but also because I'm not super familiar with the litigation relating to Pell, and I don't want to comment on the legality of that. But I will say that I have spoken to judges who talk about, for example, their work on child sexual abuse cases generally, and the ways in which that confronts them in really particular ways. Like, it's really, you know, devastating and difficult, as you would imagine. But they also see themselves as having to manage that and having to put that aside. And they think, well, not all of them, but a number of them think that they can do that successfully, right, in making a decision. And I would just say, well, it's incumbent on you to think about how you do that, right? So I'm not, of course, you know, whether it's disgust, whether it's anger, whether it's fear, whether it's anxiety, whatever you feel towards these people, you need to be able to understand what you're feeling and whether you're projecting your own feelings onto something or whether you're kind of appropriating another person's feelings. I think this is a good example of a broader problem that we see in a lot of activism generally, is where people appropriate the feelings of others as their own, right? As if they've experienced the thing that is in violence or the injustice or the abuse. And I think that's where we need to be quite wary. And I think particularly judges need to be quite wary of that as well, because often in sentencing, generally again, they articulate, I mean, lots of sentencing remarks are quite emotional, you know, particularly when they involve particularly heinous crimes, as you would imagine. But I think, again, it's incumbent for us to think carefully about whose emotion is that, right? And how is that emotion the person who's been victimized or survived a particular kind of violence, or is it the person who's making an assessment of that person's emotion and then using it in a particular way? And I think that's an area that's more dangerous, because I think a lot of people's experiences and lived experiences get lost in that process. So I think, you know, that's why I think more generally have to be wary of using law as an instrument to remedy some of these kinds of harms without recognizing the broader issues of reparations, for example, the broader issues of, you know, structural reform that law might be able to help with, but might not be able to address as well.
Okay, we'll make this the last question because we are running out of time.
Thank you, Sen, for everything you've said tonight. I'm really intrigued by the challenge of making emotion something that's legally relevant. This is pretty broad, but in this context, what is an emotion? And I'll give a little bit more to what I mean by that. Clearly, there's a difference between an emotion that manifests very quickly in a few seconds after an event, but is there some kind of psychological model you use to track an emotion over a longer period of time?
That's a really good question. So emotion has been studied in a whole range of disciplines, right? So psychology is the most obvious one. When I was doing my PhD, most people thought I was in psychology because I kept talking about feelings. But it's also been studied in philosophy, in sociology, in anthropology, and various other ways. I'm interested in what Sarah Ahmed refers to as the kind of cultural politics of emotion. That is, thinking about emotion as people talk about it, right? So not trying to define what emotion is necessarily, but focus on what emotion does. So when people talk about being angry, or when people mention anger, when people talk about fear, when people talk about disgust, how are they doing that? What are they bringing into the conversation when they talk about things that are disgusting, or when they talk about things that they're scared of? And what is the social dimension of that? And I'm interested in bringing that analysis that she does to thinking about law, and thinking about when people talk about, oh, this is gross in law, or this is scary, or, you know, talk about anxiety in the context of a decision or something like that. What are they referring to in that moment? What are they bringing together? In some ways, I'm interested in emotion as a kind of glue that holds together different kinds of ideas. So legal, you know, this particular precedent, this particular factual scenario, these particular parties, and how emotion actually holds that together in the way people talk about it. So that, to me, is how I'm thinking about emotion and kind of drawing out the social dimension as a social process, rather than, for example, talking about, the kind of neuroscientific work that's done on emotion, or the the psychological work that's done on emotion, which is also very important. But my work kind of looks more at how emotion functions as a product, as a kind of concept that emerges in law, in judgment, for example, rather than as a kind of individual experience as such.
Thank you.
Yeah.
All right, look, we will have to wrap it up there. I would like to thank all of you for coming along tonight and engaging in this important conversation. I hope you go away with lots of ideas that you can work on and ruminate on. I'd like to thank Janice of the Castan Centre for her wonderful job in organising these events. She's been with us for longer than I can remember, but she makes this run like a well-oiled machine. And finally, I'd like to thank Sam. He also spoke at the Maya School faculty today in a staff seminar at lunchtime. So we're really making him work, and I've enjoyed both presentations.
Thank you, Paula. Thank you for having me. Thanks. Fantastic. Thank you.